Would you ever settle with the debt collector when you're sued for debt? Brought to you by Ken Joubert at yourlegallegup.com, your advantage if you're being sued by debt collectors. Does it ever make sense to settle with the debt collector? Under what circumstances? When would it make sense and when would it not? Those are the questions we'll be addressing and answering in this video. Unfortunately, most people who settle with debt collectors don't do it in a way that makes sense. We talk about settling as if it's just one thing sometimes, but such a simple term and concept can mean different things, actually. And this is a classic case of the devil being in the details. So let's define settlement a little more clearly, and then we can discuss when one or the other types of settlement might make sense. Of course, at the most basic level, settling means for both sides to come to an agreement that ends a dispute. Figure that both sides, at least on the surface again, are doing the best they can to maximize their results, to get the best possible. People being sued want to pay as little as possible, while the debt collectors want to win as much as possible. That's all obvious, I know, although to look at them doing what they're doing, you might not guess it. Why? Why does it look so much like people being sued by debt collectors will pay or agree to pay anything to make the case go away? Because people being sued by debt collectors are mostly afraid of the unknown and the inconvenient. The debt collectors are comfortable and focused on getting as much as possible. But the collectees are mainly interested in making the thing go away. Paying less is only a side interest for them. Can you see what a disadvantage that is? The first thing you need to do then to pay less is to have more understanding of the time and consequences of litigation, so that you're less afraid of what's going to happen. A little background to set the table might help. What settlement does is take the parties' ideas about their positions and kind of make them permanent. If you and I both think that you're going to win a fight, I'm likely to back down or give up, right? Legal settlement is very similar. If I think you're going to win, I'll give you more, and vice versa. Let's start with settlement as defeat in debt collection cases. When people first receive notice of suit by a debt collector, their reaction is often panic. Many, and perhaps even most defendants, call up the debt collector and try to settle the debt at that point. Or they simply do nothing and let the debt collector get a judgment. They usually offer all or nearly all of the money demanded by the suit in exchange for time to make the payments. You could call those terms. To trade hard cash for soft terms is not an effective bargain. In reality, this is a fear-driven attempt to delay disaster, and a settlement on those terms is a defeat. Right? Unfortunately, all it does is bring on the disaster you're trying to avoid. It allows the debt collector to stick you with a judgment that will start hurting you immediately and will stay on your credit record for 10 years, and to collect money from you at will without warning. And they don't wait. If you say that you'll pay them $100 on the first of every month, if you pay it for 3 straight months, and then on the third month down the line you miss the first and you don't pay it right off the bat, they'll be garnishing your wages by the second of the month. They're ready to do it. Such a settlement is basically a defeat. The debt collector gets all the judgment it hoped for, plus an agreement to pay, and often information vital to its collection efforts. If you miss a payment, it can and it will initiate garnishment the very next day after you miss it. And so in reality, the consumer's attempt to delay collection has actually hastened it, plus given them some money voluntarily while they wait for something to cause you to slip up. I hate to say it, but debt collectors love to get people to do this. They like for you to miss it too. Now let's consider settlement as compromise. If you fight even a little bit, you change the terms of any agreement dramatically, and the more you fight, the better it gets in general. You might think that they wouldn't like you because you're causing them trouble, but actually, they won't like you right off the bat, but eventually they will, because they respect you for fighting. Not that that matters, But here's why you need to fight. Because if by the time you've answered and begun the fight, 2 months will have passed, and the debt collector will be looking at the prospect of spending time and money over the course of the next several months trying to win the case. They don't care about feelings. They don't care about yours. They don't actually care about theirs either. They're not allowed to. The lawyers aren't. And it could always lose. They could lose no matter how good a case looks like. You can always lose. The further into the litigation you go, the more you develop a sense of what the debt collector can or cannot do and prove in court. And usually they can't prove their case. And that's true for the debt collector. When they start the case, it never occurs to them that they might lose. If you make them start thinking they could lose, or if you make them start spending money, they start wondering whether it's all worth it. That's the way you want them thinking. That's when they start thinking of settlement as actual compromise. They take less, hurt you less, demand less. But you can do better. If you become convinced that the debt collector cannot win, and specifically if you have a counterclaim, then you will want to consider the next section, settlement, as victory. But if you're uncertain, or even if it looks pretty clear that the debt collector will win, you are still in a position to argue for a significant reduction of the dollar demand of the suit plus terms. You should do this, and you will probably accomplish both goals, even where it looks really bad. So remember that's why I sometimes recommend that people get our materials, for example, or at least fight the lawsuit for a little while. Because even if you're not going to win, once you start fighting, they will change the terms of the settlement drastically in favor of you. Why would they settle like that if they know they can win, or they're pretty sure anyway? Because you've demonstrated that you will fight. If your goal is to make as much money as possible, as the debt collector's goal is, you normally avoid a fight if possible. They take time, and they hurt. It'll cost them money to fight you, and they never really know for sure if they can actually get you to pay them in the end, even if they win. They expect to win, but they don't know if you can pay them. These guys want one thing. Can you guess what it is? 3 guesses. Collecting is hard. In these cases, the debt collector rarely collects much of their judgment, I'm sure. Although they'll keep after you, when you fight, you present them the chance that they will actually lose and the certainty that they will spend money and time that they could spend more profitably by suing somebody else. They'll almost always settle as an actual compromise as a way to get out of this difficulty. You have something real to offer in that case, and you can demand something real in return once you show that you'll fight, no matter how bad it looks for you, even if you're pretty sure you'll lose, because it's time-consuming even to win. And I'm not saying you should settle either, just that the option will almost certainly be open to you once you start fighting them. Of course, if you show that the debt collector probably or almost certainly will lose or cannot win at trial, or that there's no way they can collect, but that you intend to fight to the bitter end, win or lose, and especially if you have a counterclaim which prevents the debt collector from simply dismissing your case without prejudice, then you'll be in a position to settle your case as a victory. If you have no counterclaim, they'll often simply dismiss the case on the day of trial or the day before, and that's not terrible. It's just not as good as it could be. It leaves you anxious for longer than necessary and leaves open the possibility of them filing suit again, although they rarely do. If you have a counterclaim, they can't do that, and you can force them to dismiss with prejudice, which means that the debt is dead and gone. No more credit report damage, no more harassment. If you've got them seriously dead to rights on both their claim and yours, you may even be able to make them pay you something. Most often, though, your settlement will be mutual dismissal with prejudice. That is, both sides agree to drop the suit forever. I call that a victory for the consumer. It should be clear from this discussion that you never need to tell a judge that you would never settle. Instead, you can very cheerfully accept any invitation to discuss settlement at any time on the terms that would be acceptable to you. The further along in the litigation you are, the more favorable those terms are likely to be. So it generally makes sense to fight for a while at the beginning of the suit before you seriously consider settlement. You have time to do the discovery and the preparation that you need, and the more you do, the better the terms of the settlement are likely to be. So take your time. Give them heck. Defend yourself from the debt collectors. Don't let them rip you off. Please like this video, comment, and share it with others, as these things help other people find our materials. YourLegalLegUp.com